much, not only for the introduction, but also, of course, for the invitation to speak to you at this conference, and congratulations on the 10th anniversary. And looking forward to many, many more years to come from IRiS. I am going to be focusing on state categories, state-created categories. So in many ways, my talk today is very much complementary to what Steve did yesterday. And in fact, I think his last sentence yesterday was something about the state, so I'm picking up where he left off. We did not coordinate any of these, but it just so happened organically, so I'm quite happy about that. And also the approach that we both take to look to an examination of categories is similar, because I'm also arguing for a critical examination of categories, social categories or state-created categories, and to debunk the complexity and where and how categories are created. So very, very much aligned. My talk will, I'm going to summarize some of my most salient reflections on this topic, but a longer version of this talk is going to be published early next year. So I want to center state-created categories and classification systems that include, exclude, and neglect groups based on presumed social characteristics. I spotlight categories because they are imprinted with the power to shape the lives of those who are required to interact routinely with state agencies. Excuse me. In highlighting the contours and inner workings of state categories, I offer a lens to examine how regulations and administrative requirements sustain stratification systems, how entrenched systemic inequalities in all areas of social life are created and maintained through the quiet yet formidable workings of bureaucratic systems. This has been the core of my entire body of work in my research on the lives of immigrants in the United States, but also in my work on gender-based violence in Latin America. The approach we propose is also useful for assessing policy debates taking shape in the United States and in other major receiving countries of immigrants around the world. Take, for instance, the Deferred Action for Childhood Arrivals in the United States, excuse me, DACA, the Obama-era executive order that extended temporary protection from deportation and gave a work permit to certain undocumented youth. This year marks the 10th anniversary of the program, which has benefited over 800,000 people. But because of the age requirement and a deadline for application set in 2012 that has never been changed, most undocumented youth graduating high school this year will be unprotected because they couldn't meet the requirements to enroll in the program. Another example of the exclusionary workings of state categories is the 9.3 million undocumented immigrant workers left out of COVID-19 relief fund benefits. These are the same people who are publicly recognized as essential for sustaining critical economic sectors through their labor. State categories, in my view, shape outcomes. Deadlines, age and citizenship requirements, and regulations divide people into those who presumably deserve a particular good or benefit, and on the other side of the coin, those who don't. These demarcations are consequential for everyone, but especially for immigrants who are poor, socially vulnerable, and or those who are racialized as Black and brown. For instance, immigrants who submit a form that takes years for the system to process risk detention and perhaps deportation. And their lives, of course, will forever be affected. These are the classification systems and the state-created categories and the requirements behind those state-created categories that I'm concerned with. those on which state institutions base and justify the uneven distribution of tangible and symbolic resources, rights, and penalties. Generally, state categories and classifications are so ubiquitous and so familiar that they often fade from view. But as Paul Starr once observed, the state has no other choice but to categorize, as every state with finite resources must draw lines between people to distribute benefits and formulate a wide array of laws and policies. Through acts of commission, states exert power directly, classifying and distributing resources, but also surveying and punishing. But states also exert their power over vulnerable groups via acts of neglect and indifference, or acts of omission. The myriad classification systems, ubiquitous but seldom recognized as such, are also integral to how we see the world and understand state actions. They reveal a fundamental aspect of state power. These are the state categories I want to draw attention to, those that transform the lives of immigrants and also shape the very lenses we use to understand immigrants and immigration, which is how exclusionary systems become normalized and naturalized in people's views. I will highlight three interrelated aspects of state categories and classification systems that have emerged as critical in my own research, and I'm sure it will resonate in the research of others. First, it is their constructed nature. Political and economic interests, historical pressures, systems of oppression, racism, classism, and sexism permeate and shape formal classifications. Second, I describe how categories and classification systems become normalized and woven into informal practices in everyday life, underscoring how state power is manifested in and amplified through routine interactions, especially when those interactions happen in the context of state institutions. And third, I focus on misalignments. Because by design, formalized categories cannot capture the full range of real-life experiences, mismatches arise. Lived experiences spill over or fall in between or outside formalized categories. Examining the constructed nature of classification systems, their normalization through practice, and misalignments together can provide a powerful lens to understand how inequalities are created and sustained, but also how they can be transformed. This lens builds directly on the scholarship on the legal production of illegality, and along this critical line of analysis, I urge us all to consider endorsing this critical perspective when we are using state categories in our own work. I will first illustrate some of the effects that categories have on immigrants' lives. Categories and classification systems, even if constructed, have real consequences, as Steve reminded us yesterday, and affect every aspect of immigrants' lives, from, of course, legal status, access to housing, employment, protection from violence, education, healthcare, everything. The effects are long-term and cumulative, resulting in what Charles Tilly would call remarkably durable systems of stratification, as they are reproduced across generations with direct impacts on immigrant integration. For instance, being classified as an undocumented immigrant has dire consequences in the short and in the long term, dramatically diminishing access to formal employment and to a host of material and symbolic resources. The effects are so potent that they reverberate laterally to other members of an immigrant's family, but also multi-generationally. and in fact to entire communities. In a study I conducted in Los Angeles in 1995, I found that Guatemalan immigrant women mobilized a range of informal ties to access whatever health treatments they could procure for themselves and their families. Because their undocumented status shut them out of formal medical care. They relied on neighbors, co-workers, and acquaintances to obtain medicines, treatments, and information about cures and inexpensive clinics. 25 years later, in an ethnography that I'm currently conducting in rural Kansas with Andrea Gomez Cervantes, we find the same pattern. Undocumented Guatemalan immigrant women there also activate their informal ties to respond to institutional exclusion from the formal medical care system, as the US Affordable Care Act excludes undocumented immigrants from this benefit. Family reunification law, through deadlines and requirements, shapes the composition of immigrant families. In work with Maria Inchautegui, we found that key provisions in US family reunification law, such as caps on family preference visas, bars to re-entry after deportation, income requirements, etc., contribute to keeping families apart. In fact, we concluded that family reunification runs parallel and complementary to the enforcement practices that separate families and generate more public attention. The silent bureaucracy of family reunification, through regulations and administrative standards, reconfigures immigrant families so profoundly that it can potentially affect a larger number of families than the more visible separations through deportation. These legal entanglements often force immigrants to form transnational family arrangements that today are so common as to have become normalized. And these effects endure over time, across generations and geography, to disadvantage the children and even the grandchildren of the immigrants that the immigration system classifies as undocumented, as the work of several immigration scholars has documented. The scholarship on policing and confinement has highlighted the collateral and enduring consequences of state classifications, especially among African American men, their children, their families, and their civil and citizenship rights. And as the immigration enforcement system employed the same punitive logics as the carceral system, Latino and Latina immigrants, who are the preeminent targets of enforcement in the United States, and the more than 8 million US citizens who live with an undocumented family member, experience similarly damaging consequences as those ensnared by the prison system. In work with Andrea, the work that we're doing in rural Kansas, we are examining the experiences of Central American women asylum seekers post-detention. There we find that the costly bonds and fines and the alternative to detention programs into which they are placed keep these women and their families both system indebted and system embedded. So given the significance of state categories in immigrants' lives, I now turn to the 3 aspects of state categories that I'm going to highlight in this talk. The first aspect I want to highlight is their constructed nature. Categories, classifications, and regulations are never neutral. History, economic interests, political pressures, classism, racism, sexism have shaped them, created and shaped them. For instance, the US immigration system created 2 categories that underscore the malleability and constructedness of state categories and their commingling with larger racially based carceral projects of the state. Included in the 1988 Anti-Drug Abuse Act, the category of aggravated felony created new grounds for deportation. Originally, Originally, it was reserved for serious crimes such as murder, drug, and weapons trafficking. But this category has been expanded over the years to include a wider range of offenses. Today, it includes even minor infractions, reclassifying immigrants' traffic tickets and shoplifting as felonious and therefore deportable offenses. The broadening scope of this one category over time has contributed to the ballooning of the immigrant population in detention and at risk of deportation today. Also, as part of the larger punity projects, the United States invented the category of unauthorized reentry. Incarceration for unauthorized reentry has been in the books since 1929, but never really enforced until the 1990s, with the massive expansion of immigration enforcement under the Clinton administration, which aligned immigration control with the economically and politically more profitable and racially unequal carceral system. Today, a first-time unauthorized entry constitutes a misdemeanor, but each re-entry is classified as a felony. Since the 1990s, the prosecution of re-entries as felonies has contributed to the spectacular increase in the number of immigrants in federal custody for the crime of re-entering the country after deportation, most of whom re-enter because they left loved ones in the United States. These enforcement strategies are deeply gendered, class, and raced. Poor Latino men from 4 countries, Mexico, Honduras, Guatemala, and El Salvador, and increasingly Haiti, are disproportionately targeted, making up close to 90% of immigrants in detention and facing deportation today. The US immigration system contains numerous other examples of classified and reclassified categories. But the United States, of course, and other wealthy countries are no exception here. For instance, in an anti-Haitian racist decision, the Supreme Court of the Dominican Republic retroactively stripped several generations of Dominicans of Haitian descent of their Dominican citizenship, rendering them effectively stateless overnight. Other countries have used similar reclassification strategies to displace unwanted groups. For instance, in a review of the South American migration landscape this year, Carmen Gomez and Yoconda Herrera examined how major receiving countries in that region have changed definitions and categories of admission for the same group over time, with significant consequences for access to benefits and rights. Importantly, these laws and policies are couched in neutral, legal language, creating seemingly objective regulations and requirements. But they are not. Such regulations are suffused with class, gender, and race-based ideologies and reflect larger exclusionary systems. Consequently, their effects map onto and sustain existing patterns of inequality. I don't need to present categories or the state as monolithic. Different administrative units within the state often pursue different goals and projects. Each agency has its own requirements and deadlines. Thus, people who have routine encounters with state agencies find themselves navigating multiple classification systems at once and often facing conflicting requirements, which entraps them in multiple bureaucratic layers in enduring ways. The second aspect of categories that I want to highlight is their normalization through everyday practices. State categories have utility because they are stamped with the power of the law and integrated into institutional practices. But they don't exist in a social vacuum. People respond and mobilize to resist, change, and contest them. There is excellent scholarship documenting resistance to state classification, so I won't go into that here. But immigrants also organized to produce new categories that the state then formally incorporates. Thus, these social actors outside the state also contribute to creating and shaping categories, not just resisting them. For instance, immigrant groups have mobilized to carve out legal spaces. It was undocumented youth who organized to pressure the Obama administration to create the DACA program. And it was largely the mobilization of Salvadoran immigrants in the 1980s that led to the creation of Temporary Protected Status, or TPS, which was then included in the 1990 Immigration and Naturalization Act. 3 decades later, as the Trump administration threatened to end TPS designation for several groups, TPS holders formed the National TPS Alliance to fight to maintain this designation, but also to seek reclassification into a more permanent category. But being classified into a formal category is not a panacea, as categories do not by themselves translate into equality. Creating legal categories to capture a wider range of experiences is a first step. However, entrenched attitudes and assumptions about the people classified in those categories also must change. For instance, in a recent paper, Stefan Vogel and Rocio Rosales observed that even though the US detention system allows trans migrants to classify as such, the classification process itself exposes trans women to particularly gendered forms of punishment when attitudes, practices, and views about the people classified in those categories don't change. They conclude that carceral settings for immigrants are not only gendered, but cisgendered as well. State categories are also used in everyday practices, where they become integrated into the frames through which we see the world, and thus where state power becomes amplified in everyday interactions. For instance, when the category of undocumented immigrant, a juridical status created by law, is used in public discourse and media circles as connoting criminality, the power of this classification is amplified, as René Flores and Ariela Schachter argue with their concept of social illegality. The everyday use of state categories reinforces the belief that certain groups share characteristics by virtue of having been classified into that category. Thus, the normalized use of the undocumented category gives license to policing efforts that racially profile and target the very individuals the state creates, that the state classifies as undocumented, and those perceived to be associated with them or who look like them. Such practices go unquestioned because it's the law, and therefore it's assumed to be neutral and objective. In my research in Arizona, non-state actors such as bank tellers, business owners, and car dealer employees would ask Latino customers for proof of legal status even when it was not required by law. This quote comes from the chapter I contributed in your book. Josefina, a Salvadorian woman living in Phoenix, told me that even supermarket employees had asked her for her documents when purchasing a money order. The power embedded in these interactions is not lost on the immigrants. When I asked another woman why she thought they were asked for their documents in those transactions, she simply said, because they can. In essence, non-state actors do the governmentality work of the state, which happens when state categories become embedded in and shape everyday interactions and take place in hostile social context, where they also intersect with racialization practices. Immigrants also use state categories on themselves and on co-ethnics, which maps onto other exclusions. In our ethnography in rural Kansas, we find that indigenous Guatemalan immigrants who are undocumented are exploited and cheated by the more established non-indigenous Latinas and Latinos who take advantage of the multi-layered legal, racial, class, and linguistic vulnerability of the indigenous immigrants who come from the same country. Accordingly, when the documented binary is deployed within a community, it exacerbates existing exclusionary practices and solidifies the power of the state-created binary. We also use the state categories in our own research, often because this is how the data we use are organized, and it is also how we make our work legible to others, to colleagues. In doing so, however, we may unwittingly contribute to normalizing and enhancing the supposedly objective, neutral, and apolitical nature of the very categories we critique as constructed. And the third aspect of categories that I want to call your attention to is misalignments, spillovers and leftovers. By design, state categories facilitate the work of bureaucracies but cannot capture the range of people's experiences. Therefore, by misalignments, I mean experiences that remain uncaptured by formalized categories. Experiences spill over categories, but misalignments also result from neglect, as when the state abandons vulnerable populations. Finally, misalignments also arise in the crevices created by law, as experiences also fall in between formalized categories. In my very first article publication in 1993, I faced a misalignment challenge as I tried to fit the experiences of Salvadorian immigrants in my first project ever in San Francisco into the established immigrant-refugee binary, which to me seemed to oversimplify very complex experiences. They had left El Salvador during the Civil War in the 1980s, where crossfire between government soldiers and the opposition or a blown-up bridge often impeded travel to their workplaces. Were they economic migrants or political refugees, as the binary forces us to think? I couldn't settle this question, and instead I concluded that it was geopolitics and governmental decisions that determine who is classified as a refugee, not a mismatch between the plight of the people seeking protection and the state's definition. This became the focus of my first book. The constructed migrant-refugee binary may be bureaucratically practical and can be used to justify exclusions as well. But it cannot capture the experiences born out of a combination of economic dislocation, poverty, violence, war, and other injustices which characterize the conditions that many poor immigrants around the world flee today and whose impact they carry with them. Several scholars, including Ekaterina Kisleva and Igor Markin, have been thinking about this very issue and have suggested the term mixed migrations to refer to either the complex reasons behind migrations or the possible new legal categories that recognize this complexity. Although in principle, the concept of mixed migrations may make sense for theoretical or analytical purposes, on the ground, it actually presents some challenges. For instance, Carmen Gomez and Yoconda Herrera find that for the case of Colombians migrating to Ecuador, the state went from recognizing these migrants as refugees to categorizing them with a more ambiguous mixed migrations concept, which according to the authors, left many of these displaced migrants unprotected. Mismatches happen in multiple forms in immigrant family reunification. In work on immigrant families with Lacey Abrego and Leah Schmalzbauer, we observe that the ideological code of the family forms the state recognizes exclude many relationships that are meaningful to immigrants, such as grandparents who raised them, or cousins with whom they grew up as siblings, mismatches that lead to indefinite and painful family separations. But even when immigrants petition family members who meet state-approved definitions of kin, bureaucratic obstacles push their experiences out. Two immigrant brothers in my Phoenix study illustrate this case. Their father, a permanent resident green card holder, submitted applications for their permanent residence when the boys were teenagers. But the applications took so long to process in the system that one of them turned 21 in the process, aged out of the category, and became ineligible for the benefit. The younger brother, however, received his green card. This is one way the immigration system itself creates mixed status families, complicating life and stratifying access to resources within families. Misalignment also occurs when the state turns the other way, through acts of omission, neglect, and abandonment of vulnerable and socially divided groups. Acts of omission affect how neglected individuals think of themselves, of their place in society, and the rights they perceive to have or lack. I refer to these acts of omission as an anti-category. Instances of anti-categories abound, of groups who are denied basic benefits and protections and then experience multiple dimensions of social exclusion. This is the case of groups seeking protection, but whose plight is denied or dismissed, as in the case of Central Americans, Haitians, and Venezuelans, among others, who are currently stuck in Mexico without even the opportunity to apply for asylum. Of course, we see similar cases throughout the world today. Classification systems naturalize hierarchical systems, assigning people to categories into which they fall either in or out. But people's experiences can also fall in between categories. In fact, it is the experiences of immigrants caught in between categories, living with one foot in one legal status and the other in another, that prompted me to think more deeply about experiences in such spaces, what I have referred to as liminality. Emblematic examples include immigrants on temporary protected status, on DACA, and those who wait in limbo for years for their applications to be reviewed and adjudicated. I conceptualize experiences of in-betweenness as a condition because people in these spaces inhabit temporarily and partially two very different, even opposing categories. This is materially, socially, and existentially quite different from being classified into one or the other category. In my work, I have found that living in this condition, often for years, if not decades at a time, deeply impacts individuals' sense of self, relationships within their families, and their contacts with institutions, even emerging in their artistic expressions. But while this in-between condition is characterized by the anxiety of waiting and precarity, it also generates a sense of hope for the future and possibilities for exercising the rights that people living in this condition do have, which has given impetus, in my view, to immigrant mobilizations seeking justice. But the uncertainty embedded in these liminal conditions can subvert the gains that even a partial legal status brings. For instance, a TPS Alliance leader once explained that when his son was born there in the United States, he and his wife were advised to open a bank account to save money for the boy's college. They inquired whether they would be able to withdraw their savings in case their temporary protected status ended, and they had to leave the country. The bank said said no, so they didn't risk opening the account. The boy is now 18 and college ready, but faces multiple challenges to finance his college education without parental savings. Thus, the uncertainty of waiting inherent in this liminal condition erodes some of the benefits of being even partially documented, which affects other family members and is reproduced across time and generations in enduring ways. Moreover, individuals living in a liminal condition are forced to interact with state bureaucracies on a regular basis and are over-surveilled, as they are required to renew their permits and show clean criminal records with every renewal. These frequent contacts with immigration bureaucracies serve as reminders that they are here only temporarily and are being watched. Thus, living in a liminal condition produces a tension between these immigrants and the state. While the goal of the state may be to remove or include them only partially, their partial protection makes them vulnerable to abuses, while it simultaneously includes them by intensely surveilling them and enveloping them in the criminalization regime. To summarize, I hope that I have brought to your attention the multifaceted significance of the state through classification systems and categories of inclusion, exclusion, and neglect in the lives of vulnerable and stigmatized immigrant groups. Regardless of how misaligned the refugee-immigrant binary may be with immigrants' lived experiences, however, it is so ingrained in how we think about migratory flows that we use it in our analysis, which may reinforce the belief that the groups the state classifies into this binary may be quite different from one another. Adopting a critical perspective when using state categories in our own work can reveal how systematic inequalities are created and sustained, which can provide a different, deeper understanding of why paths of immigrant integration diverge across and within groups that highlights how structural inequalities are created by design.